When you enter the Supreme Court, you pass under the hallowed words, equal justice under law. But litigants beware in 2024. Today's court doesn't offer anything like that. It offers more power and privilege to billionaire plutocrats, power-mad kleptocrats, and crusading theocrats. Unequal justice under law is a lot more like it. Right-wing dark money groups and their friends in the Federalist Society spend untold millions of dollars to make sure they can name the justices and judges, control the docket, develop the cases, and define the jurisprudence. The result is a Supreme Court that offers nothing to the vast majority of Americans but dismantles the people's voting rights, abortion rights, labor rights, environmental rights, and consumer rights. The Roberts Court, which has been packed by the Federalist Society and stacked by Senator Mitch McConnell, builds up right-wing power by dismantling the Voting Rights Act, upholding blatant partisan gerrymanders, constitutionalizing the rights of CEOs to spend corporate treasury money in political campaigns, and approving voter suppression tactics. Meantime, it's working to undermine and gut the basic laws fought for by the civil rights movement, the women's movement, the environmental movement, the Great Society, and the New Deal. These same dark money networks produce the billionaire sugar daddies who give Supreme Court justices lavish secret gifts, including all expense-paid luxury vacations and payments for luxury custom recreational vehicles and private school tuition payments for family members. Chief Justice Roberts has refused to take any meaningful action to address the culture of corruption on the Supreme Court. Rather, he has issued a toothless, voluntary code of conduct that allows each justice to sit in judgment of his or her own ethical standing and his or her own impartiality, which violates the basic precept of our justice system. No man shall judge his own cause, as James Madison put it. Chief Justice Roberts has refused to require Justice Alito to recuse from cases regarding the January 6th insurrection, even after the world learned that flags associated with the Stop the Steal movement have flown prominently at Justice Alito's residences. The corrupting effect of all this dark money has real and immediate consequences for our daily lives. Over the past few years, under a right-wing supermajority, the Supreme Court has already made significant decisions to roll back critical personal freedoms, civil rights, and environmental protection. These include West Virginia versus EPA, which destroyed the EPA's ability to regulate greenhouse gas emissions, a critical problem as we confront the climate crisis. Dobbs versus Jackson, which destroyed Roe versus Wade and took away the guaranteed constitutional right to abortion. And Students for Fair Admissions versus Harvard, which struck down affirmative action policies in higher education institutions across the land. This term, the Supreme Court is set to decide a pair of cases that could upend 4 decades of precedent of administrative law that come under the banner of Chevron deference. On the surface, the cases are about a very technical issue, whether a regulation issued by the National Marine Fisheries Service to require commercial fishing services to pay for federal monitors to ensure that fisheries remain sustainable and viable for decades to come is valid. But what may sound technical and esoteric is in fact a huge power grab by the right-wing justices. The case tees up an issue that could allow them to substitute their partisan policy preferences for the judgment of expert agencies on a vast range of issues, from worker rights to healthcare to the environment. For decades under Chevron deference, judges deferred to career expert civil servants when they issued specific and technical rules reasonably implementing broad legislative mandates passed by Congress. Now, however, the extremist supermajority on the Supreme Court seeks to impose its own policy preferences by overriding both reasonable regulations adopted under federal statutes and the will of Congress itself. These 2 cases were nominally brought by herring fishermen, but behind the plaintiffs are the dark money networks of right-wing conservative billionaires and mega corporations, including Leonard Leo and Charles Koch. Why? Because they know that winning this case will make it much easier for them to flood the courts with cases targeting all kinds of important issues for the American public, such as the safety and effectiveness of medications and medical devices, clean water and clean air rules, civil rights protections, and fair pay and good working condition regulations. The Supreme Court is in urgent need of ethics reform to bring integrity in the federal judiciary back and to overthrow the domination of right-wing corporate interests and billionaire sugar daddies who have been systematically corrupting our judiciary. The future of our justice system, our basic freedoms and rights, and our democracy are all on the line.